Thanks a lot. Thank you very much for the invitation to the conference. I'm supposed to say some words on the relations between the Polish Constitution of 1997 and the membership of Poland in the European Union and the way the European Union system develops. So I just prepared the 4 points, so to say, in a kind of introduction to the discussion. First of all, as is mentioned also in the program, it's worth to know that the Polish Constitution was finalized in 1997. That means, parallel to the Hungarian situation, it's an old constitution, if you compare it to the new Hungarian one. That means, of course, it was prepared in the situation when Poland was outside the European Union. So in this case, it only prepared Poland to enter the European Union, rather to somehow make some detailed regulation on the Polish membership. So the idea was just to allow Poland to get into the European Union in due time. That means so we got just a general clause in the constitution concerning the membership in the international organizations, which we can transfer the parts of the competences of the Polish political institutions. That means, firstly, of course, as it's from 1997, the Polish constitution does not include any changes that happened to the European Union after the Lisbon Treaty. So it's pre-Lisbon constitution. That means it only pictures the situation of the European Union as it was in 1997, which from the EU perspective is like in Middle Ages. I mean, 13 years or more in the history of European integration is like a century. So the European Union of 1997 has got nothing to do with the European Union of 2012. That means it's from that point of view, of course, some changes are needed just to have some reflection on the post-Lisbon Union. Secondly, of course, the Polish Constitution of 1997 has no instruments for the further integration of Poland in the European Union. That means it is still the constitution of the country which, for instance, has got its own currency, and it's written in the constitution. So that means the further step of the Polish way into deepening of the Polish integration with the European Union, of course, needs the changes of the constitution, because it's still a constitution of the country pretty much that time outside the European Union, but just generally prepared to get into. And thirdly, of course, as it's now from 1997, the constitution needs to be changed also because we just have some lessons learned from the practice of the European Union. So, in 1997, which is we're still far away from the membership. Now we got some lessons learned from the membership, so we need to change the constitution. So from these 3 reasons that it does not picture the union after Lisbon, it's not preparing Poland for any further integration steps, and thirdly, because it just don't have it's obviously it's pre-accession constitution. It is a constitution to be changed because of the Polish membership in the European Union. And that's the first point that we all know, and that's pretty much the consensus in Poland, that the constitution of Poland from 1997 has to be changed because of the Polish membership in the European Union and all those things that happened after our accession. Now, this leads me to the second point. So the big question: what should be changed if the changes are needed? And then there are 2 possible ways. One of this part of the political spectrum which is closer to mine, says it has to be changed to secure the Polish rights or the rights of the Polish state within the European Union. So we have to look at these changes which are needed from the perspective of securing the sovereignty and securing the basis of the Polish politics. Because the system changes dynamically, we have to change it so to secure all the rights of the Polish state within the Union. And there's a second school saying, no, we have to change it for more Europeanized constitution. So the changes should actually be just the opposite. Less Poland, more Europe in the constitution, so to say in a mediatic way. So that means just to cross out the Polish currency from the constitution, and so on and so on. Just to Europeanize the constitution rather than to Polonize the constitution in a sense of relations towards the European Union. And this is the major, in this context, the major division, the political division. Symbolically, it's a question, should we mention the European Union in the Constitution? Which maybe is a secondary discussion, but it's not a secondary discussion. Should the name European Union be placed in the Constitution or not? Those who are saying, the first group says no. European Union is just a temporary event of the history. Now it's here. In some few years, it may be just be the part of the past story. That means, why should we put the name of the certain international organization in the constitution? We should just keep it as it is, saying that there are international organizations which Poland is a member. The second group, of course, says yes, we have to mention the European Union and just to name the whole part of the Constitution, the European Union, Poland and the European Union, and then all these articles concerning the membership should be within this special part of the Constitution called named under the title of Poland and the European Union. And this is maybe a symbolic but important division of the way the legislators, the politicians in the parliament think about the changes needed. Interesting enough, there was the compromise on that just before the last election, so in the summer of 2011, when these two groups met in the special committee of the Polish Parliament on the question of revising the constitution. There was a compromise, so both sides actually made some concession to the other. And this compromise was then blocked by the governing party because of the electoral reasons. They just didn't want to have this compromise with the main opposition party just in the age of the electoral campaign. So finally, this compromise, which was already on the table, then was blocked by because also of internal fighting between the president and the prime minister. So if you look at the documents, then you see there was a compromise on this basic changes needed, especially on the question of how the secondary European legislation should be revised in Poland. That was the main actually part of it. That's the way which brings me to the third question. On those changes needed, that means what are the new situations in the European Union seen from the constitutional perspective, and what are the consequences of this new situation? There are a few elements of this new situation in the European Union which needs to be reflected from the constitutional point of view. First of all, as we see it now, there is this tendency to reorganize the economic policy of the European Union outside the treaties, to get the treaties inside the treaties, or to get the special treaties within the European Union, which actually touches the most important part of the economic and monetary union, but it's all outside the major Treaty of the European Union and the Treaty of Functioning of the European Union. There are two of them, as we all know. One is the Treaty on the European Mechanism of Stability, European Stability Mechanism. That's the one. The second is of the new treaty on the coordination, governance, and whatever, the fiscal treaty. Just negotiating on Monday. Both of them are the treaties outside the European Union treaties. The first one, the European Stability Mechanism, is somehow encouraged into the treaties by the 136. So we are having small changes in the treaties by annexing the 136. So we have some link to the European Stability Mechanism in the treaty. So this is the only way just to a bit of camouflage for the stability mechanism, because the mechanism as itself is a new international organization, is a new international body. It's like the IMF for the European Union. So it is a new institution outside the European Union, just somehow linked to the European Union, so to have so it can look better. It was possible to do it with the previous British government. With the new British government, that was impossible to do that. So, because they wanted to copy it for the fiscal treaty as well, but that was not possible. So the fiscal treaty has not even this small pipeline to the treaties. It's even this one is missing. So the fiscal treaty is absolutely outside the new outside the European treaties. And this makes put some real doubts and questions. How then the country like Poland should act in front of this sort of new circumstances? Whatever these two treaties should be looked at as the part of the European integration. So as a part of this European Union legislation, and as a part of this whole package of the Polish membership in the European Union, or should it be looked just differently as a new treaties? that Poland is entering or not entering to the new treaties, which are completely outside the question of the membership in the European Union. So it should be according to the legislation on the international agreements and so on and so on. So it should follow the different path than the European Union within the Polish legislation and the constitution. So it should be just a normal international law, international agreement that Poland is signing. So this is the one thing. And then comes the question which is in Poland very important, specifically for us. What kind of ratification should these two treaties should follow? Should it follow the standard ratification, which means in Polish case the Article 89 with a normal majority in the parliament, or should it be treated as treaties that transfer the sovereignty to the outside organizations? That means Article 90, that means two-thirds majority, that means the position can block it. The problem is, of course, that this is a political question, because the governing majority, they have majority, simple majority, but they don't have this two-thirds majority. So they will try to push the ratification of those two treaties by a simple majority, saying that it's Poland is not a member of the monetary union, so we don't have a euro. So the treaties are obligatory only for the euro members. So as far as we don't have the euro, we can just theoretically ratify these treaties. When it comes to the question of the membership in the eurozone, then the treaties actually are in force for Poland, which is not true. That's my next point. So, and this argument for me is absolutely unacceptable. But it is pushed through the media and through the political debate, just to avoid this need to discuss the ratification of the opposition. If they do that, then we will meet in the Constitutional Court, and the Constitutional Court will decide finally. And why I'm saying it's a tricky thing, because as we all know, both of these treaties has got the 4 steps of ratification, actually, or the 4 steps of, not of ratification, but 4 steps of binding for the country like Poland, which is outside the Eurozone. The first one is signing the treaty. And we signed or we were going to sign the fiscal treaty on March. Then there is ratification, which for the fiscal treaty means nothing for us apart from that we ratify this treaty. So it's obligatory, so it's binding for us, but in fact it means nothing. Then there is the third step. By this treaty, what the treaty says, that we can declare the part of 3 and 4, which is the real part of the treaty, meaning about the budgetary control. We can declare this to be binding for Poland, and that's what the treaty says. That the countries which are outside the Eurozone can declare that they want to be bound by this Title 3 and 4. But nobody knows what does it mean, the government to declare. If we ratify it, that means it is the same decision as giving the right for the government to declare being bound by the Title 3 and 4. Or if we ratify it by 89 because we are outside the Eurozone, then this decision of getting into the treaty before we get Euro, this is Article 90, so it needs 2/3 majority. And it is the same with the European Stability Mechanism. We can ratify the European Stability Mechanism, but then it's exactly the same paragraph, that entering the European Stability Mechanism by the countries outside the Eurozone is also by the declaration of the government. So it's exactly the same. You can ratify the treaty, but then by 89, which is simple majority, but then to get into the Euro mechanism of stability mechanism, which is of course touches the sovereignty and so on, as the Title 3 and 4 of the fiscal plan. This would need another ratification, or somehow. But there is no obligation for that, and there is no procedure for that, because we have only the ratification procedure. So this is a tricky thing. And then there's a third step of getting into this fiscal treaty and the European Stability Mechanism, which is getting into the euro. Getting euro to Poland. Because when you are in the eurozone, those 2 treaties are binding for us by the definition. So then is a question whether we can join the eurozone. In which procedure we can join the eurozone? Shall we have a referendum on the euro again? Then they said no, because the accession treaty was ratified by referendum, and the accession treaty was clearly written that Poland, after some derogation, would join the euro. But then the euro of 2004, of the accession treaty, and the euro of 2012 with the stability mechanism, the fiscal pact and 6 packs and whatever, is a completely different eurozone. So is this decision of the 2004 still politically binding for the Polish nation, or can we organize a second referendum specifically on the euro? And of course, then we have to change the constitution to get the euro, because the constitution says the zloty is the Polish currency. So that means so there are further and further complications. So this shows to what extent the situation in the European Union really the climate is changing, but also the whole architecture is changing. To very mixed picture, so to say, and very tricky procedures, which actually is no one is able to clarify the situation. We just had the meeting of in the Committee of the European Integration of the Polish Parliament with Janusz Lewandowski, the Polish Commissioner for the budget, for the planning of budget, and he said that. Because I asked him about the position of Commission to the fiscal pact. He said no one understands what will come out of the fiscal pact. What would be the role of the national states? What would be the role of the Commission? And this is still to be somehow elaborated in practice, whatever that means for the basic law. And then, of course, to make the picture even more blurred, there's a question of what is the constitutional ground for so-called the Euro Plus Pact, which is a political pact, politically binding for the countries. Poland getting to the Euro Plus Pact, which is not the law, it's just a political declaration. But still, what was the constitutional ground for the Polish Prime Minister to declare that Poland wants to be a member of the Euro Plus Pact? What is the constitutional ground for giving this loan to the IMF to help the Euro countries with the budgetary problems? Why? That's breaking the basic rule of the National Bank that is reserved for securing the Polish currency. So now we are securing the Polish reserves the foreign currency, because euro is a foreign currency for us. And there is no constitutional ground for that. But it's happening. So the dynamics really is putting quite an important question marks on the Polish constitution and the constitutional practice, and we have to, I think, start in Poland a deep debate on these topics. And then, of course, there's a fourth point. The fourth point, and that's the last point. Apart from the constitutional questions, we got also the question of the Europeanization of the Polish law, which in fact, what some people say, Europeanization of the law means depolonization of the law. That means we are crossing out the whole parts of the Polish legal language and introducing the language for the directives and the European secondary law, into regulation directives. So we got very new words in Polish legal language, which has got no grounds, no debate on that, what they really mean. They are just implemented. Implementation is one of them. What does mean the transposition and the implementation? What are the difference between the transposition and implementation? And so on and so on. There are many of these new words in the Polish legal system, which has just been copied and pasted into the Polish legal system, which still needs to have a clear clarification. Otherwise, we start speaking even in the legal language of the words we don't understand. We don't understand much of the words in the political debate if we start to debate about this Eurospeak, and if we start using the Eurospeak, that sometimes it's harder to understand all these special wordings. But still, it's just a political debate. When it comes to the legal system, and we start using the words we don't understand really, that's a problem. So we can also Europeanize constitution by that way. That means to introduce the European language into the constitution, which then I think will harm the whole legal system of Poland. So that's why when I read this new Hungarian constitution, was really it wasn't moving for me to see that it was. I mean, I just wrote this in English, but At least in the first part, it tries to use the common sense language, just to use the words and the values and the names we understand even without the European Union help. And this is a very good thing, that you can still write the basic law of your country without this European context to be put everywhere in every sentence. Okay, that was my introduction. Thank you very much.